could potentially be easier for you if I didn't do this, but here's what I'm going to do. You're going to have one opportunity. Ma'am, are you Almeida Miles?
Yes, ma'am.
And Ms. Miles, the best you can, raise your right hand, please, ma'am. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. And Ms. Holmes, will your client waive the formal reading of the motion?
Yes, Your Honor.
Ms. Miles, in cause number 24, DCCR 2330, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation September 16th of 2025 for the offense of tampering, fabricating with physical evidence, a 3rd-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
The motion alleges you violated your probation. Count 1 alleges that you failed to...
Some of them are kind of redundant.
Okay, well, let's...
Counts.
We'll start with this one, then we'll see. So count 1 alleges that you failed to avoid injurious or vicious habits, in that you physically assaulted another offender in the B3 pod on or about the 6th day of November 2025 at the Henley unit, which is the ISF unit. Is that true or not true?
True.
Count 2 alleges that you failed to complete the education program, the GED program, because you stated that you were tired and did not feel like going to school so early in the morning every day. Is that true or not true?
Yes.
True or not true?
True.
Sounds ridiculous when you hear it read back to you, doesn't it?
Yes.
Count 3 alleges that you failed to enter and successfully complete the ISF program, and that you were removed based on behavioral issues. Is that true or not true?
True.
Count 4, well, it's different. Count 4 alleges that you failed to comply with all of the directions of the ISF program and that you engaged in sexual misconduct while participating at the Henley Unit ISF. Is that true or not true? And then count 5 alleges that you failed to comply with all of the directives of the ISF program and that you were walking around in the, quote, living area of the dorm during count time against the rules. And that's also at the Henley unit. Is that true or not true? That one's not true. So did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes.
All right, then I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation. What I would like to do, I'm going to reset it. I don't know that I need, because she really hasn't been out, a full update, but I would like as much information as we can get from ISF. So if they have reports that you guys can get your hands on so that I can read more about what went on there, that will help me, I think, with sentencing. Anything that you think is important for me to know, Ms. Holmes will be out there to visit with you. Tell her all of that. She'll present it to me on your behalf when we come back for sentencing, and then I'll decide what to do.
Yes.
All right, you can go back with the bailiff. So it was set for sentencing without a PSI. What was the agreement, though?
I don't know. I think we wanted to continue her, but needed to get more information in regards to her mental health. Because she was not on the mental health caseload.
Right.
And so I know probation, they were supposed to go and get more information regarding that, and they sent an email to the court.
And so I'm going to take, good morning, or good afternoon, I can't do afternoon. Are you Almeida Miles? And so we reset Ms. Miles' case for sentencing. This is 24 DCCR 2330, and Ms. Miles is currently on probation. And a motion to revoke that probation was filed, and we were here, it looks like, February 24th, and Ms. Miles entered pleas of true to counts 1 through 4 in that motion. The underlying offense is tampering or fabricating physical evidence with intent to impair, a 3rd-degree felony. And we reset, it was unagreed, and we had probation. Ms. Joseph is here with probation, find out some information with regard to whatever, I guess you could find out with regard to any type of mental health services or information. And it looks like she has not received any outpatient services with Spinal Top. that they referred her to the outpatient clinic, but you did not see where she'd ever actually had an appointment. Is that correct, Ms. Joseph?
Yes, that's from the mental health staff with Spindletop. They said that she never showed up.
And so it does look like if I were to continue Ms. Miles on probation, that Ms. Joseph spoke with a Dominique Mayfield who supervises the mental health initiative caseload, and that she advised that she would make the Tacoma referral, and that Ms. Miles could receive treatment that way. Is that correct?
Yes, ma'am. But everything is contingent on this.
For sure, yeah.
We could make services available, but if she doesn't follow through.
Totally agree. So timeline on, so part of the problem is that we sent Ms. Miles to the ISF program and that didn't work out. But the argument was that potentially it's because there were some mental health issues that had not, that's the argument. I see Miss Joseph is a little leery about that by her facial expressions. So I guess, Mr. Smith, what is any thoughts?
Well, we tried to send her to ISF and she did not complete that program.
So, Ms. Miles, the last thing I want to do is not address something that needs to be addressed if there's some mental health issues. But I also don't want.
Here is the central conflict. Accountability versus treatment. The defense suggests untreated mental health issues may explain why the program failed, while probation appears skeptical. Judges face this difficult question constantly. Was the defendant unable to comply or simply unwilling? Mental health can explain behavior, but it does not automatically excuse every violation. The judge is clearly searching for evidence before offering another chance that could easily backfire.
Want to be played and use that as a reason for me to continue on probation when that's really not why you violated or couldn't get through ISF. Does that make sense? Ms. Holmes?
I would be requesting that the court give her a chance to receive the mental health services. My apologies.
Okay. Of all times for it to happen.
Sorry about that. But I would like to see if she could receive the services. It looks like the history with her being on probation and does have a lot to do with how she handles situations, attitude, things like that, which I think.
The attitude and mental health are two different things, and that's where I am. That's my issue here, is this just a bad attitude problem, or is there really a serious issue that needs to be addressed? From the ISF documents, it looks pretty much like an attitude problem and not a mental health problem.
Everything has now led to this moment. The violations are proven. The previous program failed, and the judge could legally revoke probation, yet she is considering one final alternative. Intensive mental health supervision. Listen carefully to the language that follows, because this is not mercy without consequences. This is a last chance agreement where even one missed meeting or failed instruction could turn freedom into a prison sentence almost immediately.
Ms. Joseph, anything to add?
I don't deny that Ms. Miles has mental health issues, but I don't subscribe to the fact that the behavioral issues at the intermediate sanctions facility, coupled with the disciplinary infractions at the county correctional facility, constitute mental health issues. However, should the court elect to continue Ms. Miles on probation, that the full plan is, and everything is already in her conditions of probation, she will be transferred to a mental health caseload where that officer can get the Tacoma referral. And if everything goes well, she'll be supervised on that caseload for a year. Then she'll come back to my caseload where she'll be supervised again for a year. and to assess her progress before we transfer her to a regular felony case.
All right. So here's what I'm going to do, Ms. Miles. And
That distinction is absolutely crucial. A mental health condition may require specialized treatment, but disrespect, fighting, and refusing instructions are not automatically symptoms of illness. The court must avoid two dangerous mistakes: punishing someone for genuine medical struggles or allowing ordinary misconduct to hide behind a diagnosis. Right now, the reports are leaning toward an attitude problem, and that makes the defense's request for another opportunity much harder to sell.
it probably could potentially be easier for you if I didn't do this, but here's what I'm going to do. You're going to have one opportunity at this. All right. And I want to make that very clear because Ms. Holmes is listening to me. Mr. Smith and Ms. Joseph knows that when I say this is your opportunity, this is it. If you don't take advantage of what I'm about to do, there is no ISF. There's no special needs safety. There's none of that. I don't want anybody coming back and asking me for any of that. It'll be a revocation, and it'll just depend on what I decide to do based on the information that I have at that time, how long you go to prison. But you'll probably be going. Do you understand? So they're going to give you all the help you need. It's up to you to take advantage of it, just like Ms. Joseph said. So I'm going to find that you entered your plea on that motion to revoke freely and voluntarily. Find those counts true, find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. I am going to continue you on probation. I'm going to order everything that Ms. Joseph just said. You will be on the specialized mental health caseload. You will get a referral to the Tacoma program. They will explain all of that to you, and you will be required to go to every meeting, follow through with any medication. All of those are now court orders. So whether you think you need the class, the meeting, the counseling, the medication, at this point, I'm ordering you to do whatever they say is best for you. You will be on zero tolerance. So what that means is that there's no, I just missed a meeting or I just missed something, give me another chance.
Zero tolerance means exactly what it sounds like. There will be no comfortable warning period. Next time, counseling, medication appointments, and respectful behavior are no longer suggestions. They are direct court orders. The judge has created a structured path designed to help her succeed, but responsibility now rests entirely on the defendant. Do you think this strict final chance will motivate real change, or are we watching the countdown to another revocation hearing?
This is your chance. If you mess up, you'll be right back in here, even just with one mess up. Does that make sense? All right. Anything else, Ms. Joseph, that you think would be appropriate for me to order?
I did want to clarify that upon her completion of the MHI caseload, she'll come back to high
Yes.
Okay.
Then you'll go from the mental health caseload to the high medium caseload. That way you're not going from one super intensive to just kind of once a month. You're going to have a structured kind of step down process so that everybody can make sure that you're doing and everything you're supposed to, and that you're in a place where you're able to do that. Or if you need any further help, they'll get you that as well. All right. The disrespect and all of that, there's nothing that I can tell from any of the reports that I have that would show that there's some reason, mental health wise, for you to act the way you're acting at some points. Right. So that's not making you do some of those things. So I want you to be respectful to wherever you're going, the probation department, Spindle Top, wherever it is. You have to treat everyone with respect along that way, that path. Okay. I'm going to hand you the trial court certification. This shows this wasn't an agreement. There are some rights to appeal, but you can talk to Ms. Holmes about that. If y'all will sign that and give her the bottom copies.
Okay.
And I hope you take advantage of this opportunity. Okay. Good luck to you, ma'am.